Welcome to the Turnaround Podcast with your host, Stephen Phillips. In each episode, Stephen speaks to experienced practitioners who discuss their careers, key moments, challenges, and lessons learned in financial turnarounds and business restructuring. Join us as we unravel the secrets to turning struggling businesses into success stories. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, frilibertas.com. Now, here's the host of the Turnaround Podcast, Stephen Phillips.
Okay, so welcome to the Turnaround Podcast. This week, we turn the focus to Ukraine and its environs. Whilst the media obviously and understandably highlights Ukraine's resistance to the Russian invasion, there is, of course, a lot going on in the corporate world. Ukraine needs investment to rebuild its economy. I am delighted that I have a very special guest to bring some light on what is going on in Ukraine. James Hart is a partner and co-founder of Hillmont Partners, a Ukrainian law firm. James heads the private client practice and co-heads the cross-border dispute resolution practice. James has advised the former PM of Ukraine and the Vice Prime Minister of Ukraine, and he has advised on policy relating to the investment climate and the rule of law. His practice is focused on investment planning, asset structuring, acquisition, and asset protection, cross-border transactional and litigation support. He focuses on special sits and the enforcement of creditor rights. James's language skills means that he works on situations outside of Ukraine, and we have been working together on a fascinating situation which has many jurisdictional touch points, including Moldova, Kazakhstan, and the BVI, which we will shortly talk about. James Hart, welcome to the Turnaround Podcast. Thank you so much for joining us.
Thanks, Stephen. I'm delighted to be here. Thanks for having me on the show.
Well, James, as people can probably hear, you're an Englishman. You're based in London, and yet you're a partner in a Ukrainian law firm. It's an unusual background. I think the audience would want to know, how did you get started and how you got to where you are today?
Yes, an unusual background indeed. And it all started about 14 years ago when I was plucked out of a bank I was working in at the time by a client and asked to move to Ukraine and lead a team to manage the acquisition of what was at that time one of the largest alcoholic beverage manufacturers in the former Soviet Union, and it was a classic special situation. And yeah, I got there and didn't look back. I lived in Ukraine right through till 2020, and during that time, set up the firm.
And how did the Hillmont come about? So this is the partnership you're currently with.
Yeah, so I mean, it has its roots in that acquisition I mentioned. It was a very the business itself was being ripped apart by its creditors in various jurisdictions, and we came in and we bought out trademarks, production assets, distribution channels from various competing creditors, and then as we I think understood when we went into it, we then spent the next 5 years or so litigating with other creditors. It was a pretty huge capital stack, and a lot of creditors were pretty stung by it. So unsurprisingly, we were locked in quite a few legal battles, and really the epicenter of those were in Ukraine. Hence why I decided to base myself there. And it was through through that those disputes that I met the two partners with whom I eventually set up Hillmont in 2016. They were the ones tasked with defending us in the Ukrainian courts, and we became very good friends, and decided there was quite a lot to be done. Quite a few, especially foreign investors, that were facing some difficulties in the Ukrainian courts or with Ukrainian law enforcement, and yeah, we teamed up, and that's how Hillmont was born.
Excellent. So what does the firm do at the moment, both in Ukraine and in the broader region?
Well, we started out as a pure litigation firm, pure disputes at the very beginning, but we started to expand quite quickly into other areas of law. Today, we are a full-service firm handling transactional work, litigation, arbitration, criminal litigation as well. We have a strong government relations practice as well. So, and of course, the a majority of what we do is in some way related to Ukraine, but specifically my team in the international dispute resolution practice. We are also involved in a number of matters that have no Ukrainian link, but are cross-border matters within the CIS region, and so that's actually a pretty large part of our business as well.
What is the, I guess, the cultural background here? That what is the special sauce perhaps that you bring that maybe people advising from the outside might not be able to bring?
Well, I think that litigation is conducted in many respects differently in the region, both within the country. So within, for example, Ukraine itself, in terms of how do you ensure that you are maximizing the chances of success when there are some significant weaknesses, institutional weaknesses in the country, but and knowing what it is that you're if you're litigating, what your opponents are likely to try, and to just make sure that you're a few steps ahead. Unfortunately, there are a lot of cases where there have been very well advised big international players who have had excellent legal counsel, strong global counsel, who just were understandably, in some senses, wrong-stepped by a counterparty normally in situations where there has been some sort of pretty brazen unlawful conduct. And I guess it's just being alert to what those techniques and what those tactics are, and preparing for them. And that I think spills over also into the cross-border context. A lot of the jurisdictions which come into play with countries like Ukraine, or also in the region, Azerbaijan, Moldova, and other places, often involve similar offshore jurisdictions, holding companies in those jurisdictions, and litigants from that part of the world are actually pretty creative in those circumstances, in those jurisdictions too. And so I think it's not just about knowing and planning for what you might encounter within the let's say the main jurisdiction, but also in the related and ancillary jurisdictions as well.
Got it. Yeah. Without sort of breaching any sort of confidence, is there an example of a current case that you can talk about?
Yeah, there's a relatively public case that we're advising on at the moment in Ukraine. It's quite a wide cross-border matter involving multiple jurisdictions, UAE, Cyprus, Switzerland, Ukraine, of course, England, and I think it's a pretty good case study for Ukraine itself, and I think the case it's ongoing, and I think it is a litmus test for to what extent the Ukrainian legal system, the criminal justice system as well, is fit for purpose and can actually protect foreign investor rights, any investor rights, but in particular being looked at carefully by anyone considering investing now or in the future in Ukraine. The case it has taken on quite a it has become quite public just because of its scale, because of the parties involved and the underlying asset, which is a number of grain exporting assets in the port of Odessa, some of the largest transshipment terminals on the Ukrainian coast and the Black Sea. And it involves two US investment funds that between them lent approximately $95 million a few years back, so 2019 to 2021. The debtor group in question was actually in default as early as 2020, 2021, and there'd been a lot of work to try and come to to try and restructure the debt, to include waivers and give them space to meet their obligations in the future. What was unfortunately very disappointing in this case was that the full-scale invasion in 2022 by the Russians became essentially very cynically a tool to turn around and say, sorry, we've lost all of our inventory, and without any credible, plausible explanations, 400,000 tons, $130 million worth of grain is apparently irretrievably spoilt, and with no explanation whatsoever, and pretty tough in a if you can imagine the position that the creditors were put in. There's an invasion that's just taken place. There has to be enormous sensitivity to that. I mean, maybe really 400,000 tons has gone missing, and maybe it is because of the related to the invasion. So of course, huge sensitivity was taken at that point by the creditors before deciding that they had to enforce. But the explanations that were being provided were so inconsistent and implausible that in the end, in December 2022, the decision was to enforce, and what's entailed since then has been a pretty staggering defense that's been mounted by the other side, involving some extremely unsavory actions of instances of asset dissipation, not just the grain disappearing, but then also stripping out assets through local Ukrainian banks, having those banks basically lend them money, pledging those assets, foreclosing on them, and then pushing them out onto affiliated party structures. And just basically stripping the assets out of the borrowing group and putting them out of the reach of creditors. And this is now being heavily fought in the Ukrainian courts. There have been over 100 claims and injunction applications filed in the courts since enforcement began. So this is, we're talking a couple of injunctions sort of popping up a week sometimes. And there's also been actually, what I would a very good way of sort of getting to the nub of what happened here was in an English High Court worldwide freezing order judgment from February this year, where the description of how assets were dissipated goes into, in the judgment, the judge goes into quite some detail, analysing the so the implausibility really of what was done. So it's an important case because it deals with we're seeing how the courts are operating right now during a war period. Actually, the kind of the short conclusion in my book is that there have been some very balanced and reasonable outcomes in the Ukrainian courts in this period. In this case, the bankruptcy courts in particular have shown themselves to be pretty robust and unwinding clearly illegal actions. The Supreme Court has ruled numerous occasions in favor of the creditors, upholding the bankruptcy court's decisions at the lower instances. And I think it's it's been in many cases a positive case study in terms of how the courts can operate in Ukraine. On the other hand, what has been a hallmark of this has been really abusive use of injunctions applied for in random regional courts where there's a single judge. Nothing, the region has nothing to do with the dispute, and lo and behold, they get some absolutely obscene injunction out of nowhere to block steps, and they will do that, as I say, that dozens of times, over 100 times, making it difficult to proceed with the enforcement. So it's an interesting case with which, as I said, I think will be an important test for and will be watched closely by many investors who are looking at Ukraine.
Yeah. Well, I think the theme of today, in a way, is restructuring, rebuilding Ukraine, and if foreign investors are basically ripped off, and if the court systems don't support them, then you can probably forget investment. So what you're doing is a pretty important test case. I would have thought it's probably like the most highest profile test case at the moment in Ukraine, I would imagine.
I think that's probably right. Yes. And it's infuriating. What has been, where there have been some successes in the courts, what I've been particularly infuriated by in this case is the criminal justice system, because there have been some pretty clear instances of entirely unlawful, egregious misconduct. And for example, one of the explanations given as to where some of a huge proportion of this grain went, they said, well, it had to be trucked out to Sumy region, about 11 hours from Odessa, back in May of 2022. So just not long after the Russians had been kicked out of Sumy, and taken to a sort of derelict, as it turned out, as we checked, sort of this derelict building that was apparently a place where you could incinerate, tens of thousands of tons of grain. And then, when the owners of that sort of derelict building were asked, did you incinerate all of this? They said, no, absolutely not. That should be something that law enforcement, become involved with quite, I would expect quite robustly in instances, especially in this sort of scale. And unfortunately, there's just been absolutely, there have been so many blockages put in place that the reform of the criminal justice system is going to be absolutely key to persuading many investors who aren't used to investing in the region that it's time to come in.
Okay, great. Well, let's switch gears. I alluded at the beginning in my intro that we've been working together on something for about 3 years. It's a sort of very interesting special situation. It relates to an oil company called Tristan Oil, which is a Kazakh oil company owned by the Statis, which are Moldovan based business people. we've just sort of passed a rather special milestone in that case. But I think the audience would really like for us to make any sense, perhaps for you to sort of give us a bit of background about the case and what was going on there.
Yes, yeah, no, it's been and it's a fascinating case, and it dates back to really the late noughties, when our clients owned and ran a really extremely successful oil and gas business in Kazakhstan. And as happened at that time, if you got a little bit too successful, people would come round knocking and saying, "Hey, we quite want a piece of this." And ultimately, when our client responded that that's not an option here, this is my business, there proceeded to be a huge campaign driven by multiple governmental agencies, including the financial police and environmental agency and so on, all coordinated to strip the asset and essentially expropriate the asset. And that all culminated in about 2010 and led to an energy charter treaty arbitration in Stockholm, and an award in favour of our clients against the Republic of Kazakhstan for over $500 million. This the business didn't. It wasn't only our client; it was also that suffered loss. It was, of course, also a number of large international financial institutions that were bondholders of that group of companies as well, and all faced with the loss of this business. And so what then transpired was a process to enforce the award. And as anyone who's involved in investor state enforcement, it can be a pretty complex process. And so for since that award was made in end of 2013, there then ensued over 10 years of enforcement, and enormous. This is across multiple jurisdictions, and extremely hard fought, and the cost that was incurred both on the part of the Republic and on the part of the starting parties, our clients, was astronomical. And that's where we got to last year. And you and I, Stephen, or I think it's starting a bit before that, you and I started working together on restructuring those liabilities, because it had got to the point where fresh funding was needed to continue pursuing the enforcement of the award. And you had to work out a way how to fit that new funding into the capital stack. So for me, it was a fascinating process. I think one that you have done many more times than me, but I think it was a particularly interesting one, and it was a great fun working on it together.
Yes, yeah. I mean, it's probably worth just saying to the audience like what we actually did on a technical basis, because it was an interesting case in that you have bondholders who are all over the world. So Tristan Oil had issued some bonds under New York law, high yield bonds. There were also other stakeholders involved who put a lot of money into the case over the years, including the previous lawyers who had successfully achieved the award, but were owed considerable sums, and that those sums had increased because there'd been a need for litigation finance. So there was a lot of liabilities, and as you say, there was a need for new money to come in. I got involved really. One of the stakeholders, one of the bondholders, gave me a call and said, "Can you get involved?" And I teamed up with the guys at Astria Group, which is a London-based boutique law firm, and I sort of came along alongside them to help put that scheme in place. And we also we sort of thought, well, the best way of doing this would be to use a BVI scheme because the Tristan Oil was a BVI company. So the scheme effectively just rearranged people's entitlements, making sure that the top entitlement essentially was going to be the new money coming in, and that's often the way with a restructuring. New money, gets seniority, and not everyone was happy at first. I mean, we probably had a few initial hearings where some of the stakeholders weren't delighted to hear that their entitlement wasn't going to be quite what they thought. But without that money coming in, the entitlement was going to be zero. So I think eventually common sense prevailed, and we all ended up with a consensual restructuring, which was then put through the US courts. These bonds were New York law governed, so we needed a Chapter 15 filing to get recognition in New York. But it was interesting. This was a case where the Kazakhstan authorities actually tried to intervene. That was an interesting intervention. I don't know if you had any thoughts on that, James.
Well, it certainly. I think it was certainly made the process more complicated. It was ultimately, and I think the BVI is making more and more of a name for itself in terms of schemes of arrangement, because I think the court was very sober-minded in this. It can be difficult when a sovereign comes in, and a sovereign is, it's on a priori, it's on a pedestal, but saw that the intervention essentially to try to prevent new money coming in to enforce an award against that party, was pretty self-serving. And there were the arguments that were made were that the arbitral award itself had been tainted by fraud, and the BVI court rightly looked to the curial seat of the arbitration, to Sweden, and who has already ruled multiple occasions and up to the Supreme Court that that the award is not tainted by fraud and is fully valid. So it was an additional spanner thrown into an already pretty complex works, but we it came through in the end, which was excellent.
Yeah. And I must admit, you mentioned the BVI courts. I mean, I was very impressed actually with the robustness of the courts, with how the system worked. There were electronic hearings. There were some in person, but it seemed to work very well. At first, I was a bit nervous because I had been more used to doing Cayman schemes where there's a bit more of a history there. There was a case I was involved in called Ocean Rig a few years ago that went very well. So it was very good to see that the BVI was robust and worked out. And we should give a shout out to our lawyers there, Walkers, who I think did a tremendous job. So without them, that wouldn't have happened. And there were lots of huge numbers of stakeholders involved in this. So hopefully we're not giving the impression it was just you and I, because I know it's a big effort. But I think I think it's probably worth flipping into saying, okay, so we had that very big legal process. Eventually we got the scheme hearing, and we got the sanction that came through. We got the Chapter 15 filing that came through as well. So in a way, what had happened is we probably demonstrated to the Kazakh government that, well, we had some new money, we weren't going to go away, and maybe you can take up the story in more recent times, James.
Well, yeah, well, we've, we're the milestone you mentioned earlier was reached in July, so just over a month ago, in fact, when it was publicly announced that our clients had signed a framework settlement agreement with the Republic of Kazakhstan and the National Bank of Kazakhstan, and that is quite a milestone when you've got the history of this case, 15 years of the eye-watering expense. I think it is a really great milestone. I think in part as well, I think it is also it's an indicator of positive change in Kazakhstan itself. The people that took this asset in the first place, and their affiliates and associates that then launched the campaign to avoid its payment, are no longer in power in Kazakhstan. And I think this is an indicator, a little bit like we were talking about what indicators there could be for Ukraine and investors looking at it as an investment jurisdiction. I think this is a real positive development for Kazakhstan watchers, and shows a clear move away from the antics of the old regime. So it's I think a really important step all around, really.
Yeah, good point. I mean, the commercial terms are confidential at this stage, so we can't really go into that. But I endorse that it looks like a positive step forward. And I guess moving on to to Ukraine, actually, where we started a bit more generally. What do you think the opportunities are at the moment in Ukraine? I mean, in some ways, it sounds a bit crazy to talk about investments and corporates and all sorts of things when there are sort of bombs falling, etc. But I guess that's the nature of business, to always sort of be still looking at the future.
Yes, yeah. Well, I think it's important to point out that there are enormous swathes of Ukraine that are not under missile attack or had any have any real disruption from the actual military aggression. Obviously, there are economic impacts to all of this. That goes without saying. But it is it is there are the risks, I think, can easily be over exaggerated. The risk of there's something happening to an asset if it's, let's say, been constructed somewhere in Western Ukraine. But it is, of course, at the front of minds of anyone looking at how do you invest? How do you explain to your stakeholders that you have invested in a country that is at war? But what we do see at the moment is that there are companies, there are investors that are more and more, well, we are seeing more and more investors and corporates that are in some cases actually investing, putting proper investment tickets into the country, or are preparing to, and are already engaging in due diligence, looking at projects, and working with local counterparties to invest in those. And I think the opportunity here is to time this this correctly, and I think a lot of people think the timing now is the correct time to back strong Ukrainian companies and projects that are going to be very well positioned for the post-war reconstruction. And there's going to be, I think it's a pretty much a given that there is going to be a lot of investment in the medium term into Ukraine. I think Ukraine's European accession ambitions are rightly held, and that process is already kicked off. So it's an opportunity for those who time it right and who get in not too early but early enough, and are backing solid Ukrainian corporates to make a lot of money. At the moment, we're not seeing the kind of many financial investors, large blue chip financial investors throwing their hat in the ring, but we are seeing emerging market funds already beginning to get involved, and corporates that already have businesses there making acquisitions and increasing their capacity in the country. And also a lot of high net worth individuals are becoming more and more interested, and often they are the lead indicator when the slightly the higher risk appetite high net worth individuals start getting involved. I think it's they sort of lead the pack. So I think there is a lot of opportunity, and I think also because there's so much G7 governmental backing, there are opportunities to team up with IFIs and also to tap into war insurance and political risk insurance programs that have been launched. So I think there's a lot to be done, and I think investors are rightly looking at Ukraine now.
Yeah. Well, that's positive. I guess there is a current situation going on, which is the sovereign debt default that Fitch just demoted Ukraine to restricted default. Any thoughts on how that might get resolved?
Well, it's a delicate balance on both sides, both on the government side and on the bondholders side. I think the heart of the kind of trade-off here is to what extent should the private sector, private bondholders take a hit, given it is entirely understandable why Ukraine is unable to service its debt as it would normally. It is fighting an incredibly resource intensive war, the most resource intensive war since the Second World War. Not surprising that it can't be business as usual. But I think the question therefore is not should Ukraine can Ukraine be provided with alternative solutions. The question is, who is going to foot the bill for that? Is that going to be the taxpayer of Ukraine's allies, or is it going to be bondholders that are going to take a hit, or is it going to be a bit of both? And I would expect that it will probably be a bit of both. But I hope it is. I hope it is solved, and Ukraine is preserved, from and allowed to focus its resources on winning its war.
Yeah, good. Well, James, thank you so much for sharing your thoughts. Obviously, I wish you good luck in all your various cases, and it's been fascinating talking to you. Thank you for joining us.
It's been a pleasure. Thanks, Stephen, for having me.
You've been tuning in to the Turnaround podcast with your host, Stephen Phillips. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, freilibertas.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.